Chapter 2. The Conduct of Business in a Deliberative Assembly. 3. Basic Provisions and Procedures. The basic parliamentary concepts and practices are interconnected in such a way that a complete statement of the rules that relate to any one of them frequently involves reference to several other concepts. This section contains an initial explanation of a number of these topics, which are given a more detailed treatment later in this book. In reading all that follows throughout this manual, it should be borne in mind that, as in any treatment of any subject, a statement of a rule generally cannot include all possible exceptions to the rule. Whenever a particular statement appears to conflict with a more general statement elsewhere in the book, therefore, the particular statement governs in the matter to which it states that it applies. See also 5668.3. Minimum composition of a deliberative assembly. Quorum of members. The minimum number of members who must be present at a meeting of a deliberative assembly for business to be validly transacted is the quorum of the assembly. The requirement of a quorum is a protection against totally unrepresentative action in the name of the body by an unduly number of persons. In both houses of Congress, the quorum the quorum is a majority of the members. By the United States Constitution, such a quorum is appropriate in legislative bodies, but too large in most voluntary societies. In an ordinary society, therefore, a provision of the bylaw should specify the number of members that shall constitute a quorum, which should approximate the largest number that can be depended upon to attend any meeting except in very bad weather or other extremely unfavorable conditions. In the absence of such provision in a society or assembly whose real membership can be accurately determined at any time, that is, in a body having an enrolled membership composed only of persons who maintain their status as members in a prescribed manner, the quorum is the majority of the entire membership by the common parliamentary law. In the meetings of a convention, unless the bylaws of the organization provide otherwise, the quorum is a majority of the delegates who have been registered at the convention as in attendance, irrespective of whether some may have departed. In a mass meeting, or in a regular or properly called meeting of an organization whose bylaws do not prescribe a quorum and whose membership is loosely determined, as, for example, in many church congregations or alumni associations, there is no minimum number of members who must be present for the valid transaction of business, or, as it is usually expressed, the quorum consists of those who attend the meeting. The rules related to the quorum are more fully stated in Chapter 40. Minimum officers. The minimum essential officers for the conduct of business in deliberative assembly are a presiding officer, who conducts the meeting and sees that the rules are observed, and a secretary or clerk, who makes a written record of what is done, usually called the minutes. If the officers are members of the assembly, as they usually are in ordinary societies, they are counted in determining whether a quorum is present. The presiding officer should be placed so that, even when he is seated on a high stool if necessary when behind a lectern, he can see the entire hall and all present can see him. See also 47.5. The presiding officer's official place of station, usually in the center of the platform or stage if there is one, is called the chair. During meetings, whoever is presiding is said to be in the chair, whether standing or seated at the time, and he is also referred to as the chair. The phrase the chair thus applies both to the person presiding and to his station in the hall from which he presides. The secretary's desk should be placed so that papers can be easily passed to him from the chair during the meeting. The duties of the presiding officer, the secretary, and other officers that an assembly or society may have are described in Chapter 47. Pattern of formality. Customs of formality that are followed by the presiding officer and members under parliamentary procedure serve to maintain the chair's necessary position of impartiality and help to preserve an objective and impersonal approach, especially when serious divisions of opinion arise. Customs observed by members. The president or chief officer of an organized society, who normally presides at its meetings, is then addressed as Mr. President or Madam President, whether a married or unmarried woman, Mr. or Madam Moderator, or by whatever may be his or her official title. In the lower house of a legislative body, this officer is most commonly Mr. or Madam Speaker. The Vice President is addressed as Mr. President or Madam President while actually presiding. A possible exception may arise where the usual form would make the meaning unclear. For example, when the Vice President is in the chair while the President is also on the platform. In such an incident, the Vice President is addressed as Mr. or Madam Vice President. A person presiding at a meeting who has no regular title, or whose position is only temporary, is addressed as Mr. or Madam Chairman by long-established usage. Several variations of this form, such as chairperson or chair, are now frequently encountered, however, and may be in use as the general practice in particular assemblies. Even in a small meeting, the presiding officer of an assembly is not addressed or referred to by name. The only exceptions that might arise in an assembly, note, as distinguished from a small committee, whose relaxation of this rule may be appropriate depending on the conditions, back to reading, would be in cases of a testimonial nature, such as in the presentation of a gift to a president who is about to go out of office. With nearly the same strictness of observance, he is not addressed by the personal pronoun you. Although occasional exceptions may occur in ordinary societies, a brief administrative consultation takes place during a meeting. As a general rule, when additional reference to the presiding officer is necessary in connection with addressing him by his official title, members who give him as the chair, as in, Mr. President, do I understand the chair to state? Members address only the chair, or address each other through the chair. In the parliamentary transaction of business, within a latitude appropriate to the conditions of the particular body, members generally should try to avoid mentioning another member's name whenever the person involved can be described in some other way, such as in, Mr. President, may I ask the member to explain? Or, Mr. Chairman, I hope that the gentleman who last spoke will think of the probable consequences. With a very limited number of particular exceptions, and excepting committees and small boards, a member never speaks while seated. Note, a member who is unable to stand is permitted to speak while seated. And back to reading. And with a slightly larger number of exceptions, a member does not speak without first having obtained the floor, as described in 330 through 35. Customs observed by the presiding officer. The presiding officer speaks of himself only in the third person, that is, he never uses the personal pronoun I. In actual parliamentary proceedings, he always refers to himself as the chair, as in the chair rules that. At other times during meetings, such as when he makes a report to the members in the capacity of an administrative officer of the organization rather than as presiding officer of the assembly, he may, if he wishes, describe himself by his official title, as in, your president is pleased to report. Strictly speaking, the chair does not mention a member's name and does not address an individual member as you, except in connection with certain disciplinary procedures. Instead, he may say, for example, the chair must ask the member to confine his remarks to the merits of the pending question. In practice in an ordinary lay assembly, however, there are a number of occasions when the chair often refers to members by name, such as when assigning the floor, that is, the executive right to be heard at that time, as explained in 330 through 35, or when announcing the members of committee. For more complete explanations of the general forms observed by the presiding officer and members in assembly, see chapters 42 and 43. Call to order or order of business. When the time of the meeting has arrived, the presiding officer opens it after he has determined that a quorum is present by calling the meeting to order. He takes the chair, that is, occupies the presiding officer's station in the hall, waits or signals for quiet, and, while standing, announces in a clear voice, the meeting will come to order, or the meeting will be in order. For the procedure to be followed when a quorum of members do not appear, see 46 through 10. The call to order may be immediately followed by religious or patriotic exercises or other opening ceremonies. The initial procedures in a mass meeting or in one called to form a society are described in chapters 53 and 54. Meetings of permanently organized bodies usually follow an established order of business that specifies the sequence in which certain general types or classes of business are to be brought up or permitted to be introduced. If the assembly has no binding order of business, any member who obtains the floor, see 330 through 35, can introduce any legitimate matter he desires, within the objects of the organization as defined in its bylaws, at any time when no business is before the assembly for consideration. A society may follow the order of business given in the manual that the bylaws of the organization designate as its parliamentary authority, or it may have adopted its own particular order of business. Although an organization has no binding order of business until it has either adopted its own or has adopted a parliamentary authority that specifies one, the following order of business, which is fully explained in Chapter 41, has come to be regarded as usual or standard for one-meeting sessions, see Chapter 8 of Ordinary Societies. 1. Reading and approval of the minutes. Note: the order of business is separate and distinct from the procedure of calling a meeting to order, which is not a part of the order of business. A meeting opens by being called to order even when it has no established order of business. Additional calls to order may occur during the order of business at various times not specified in advance, if the assembly takes a recess, see chapters 8 and 20, or adjourns to a future time, chapters 8 and 22, before the order of business is completed. For these reasons, it is not proper to list a call to order as the first item in an order of business or agenda, as is often incorrectly done. Back to reading. 2. Reports of officers, boards, and standing, that is permanently established, committees. 3. Reports of special, select, or ad hoc committees, that is, committees appointed to exist only until they have completed a specified task. 4. Special orders, that is, matters which have previously been assigned a type of special priority, as explained in chapters 14 and 41. 5. Unfinished business and general orders, that is, matters which have come over from the preceding meeting or which have been scheduled for the present meeting. 6. New business, that is, matters initiated in the present meeting. In a meeting where an established order of business is being followed, the chair calls for the different classes of business in the prescribed order. A mass meeting usually requires no order of business, since, referring to the headings listed above, there is nothing but new business to be brought up, unless the meeting is one within a series. A convention commonly adopts its own order of business, which often specifies the exact hours at which certain important questions are to be taken up. The order of business of a convention is known as the program or the agenda, depending on whether it is interwoven with or separate from the overall schedule of convention, meetings, events, etc. See chapters 41 and 59. A legislative body usually has a more elaborate order of business suited to its own needs. Means by which business is brought before the assembly. Motions. Business is brought before an assembly by the motion of a member. A motion may itself bring its subject to the assembly's attention, or the motion may follow up on the presentation of a report or other communication. A motion is a formal proposal by a member in a meeting that the assembly takes certain action. The proposed action may be of a substantive nature, or it may express a certain view or direct that a particular investigation be conducted, and its findings be reported to the assembly for possible further action or the like. The basic form of motion, the only one whose introduction brings business before the assembly, is a main motion. There are also many other separate parliamentary motions that have evolved for specific purposes. While all of these motions propose some form of action, and while all of them are said to be brought before the assembly when they are placed under consideration, most of them do not bring business before it in the sense described above, as a main motion does. Many of these motions involve procedural steps relating to a main motion already being considered. The main motion sets a pattern from which all other motions are derived. In the remainder of this chapter, rules and explanations relating to motions have the main motion as their frame of reference. The manner in which a main motion is brought before the assembly is explained in 4.2 and following. Motions growing out of reports or communications. After the presentation of the report of an officer, a board, or a committee, one or more motions to carry out recommendations contained in the report may be introduced. For the procedures in such cases, see 41 and 51. A motion may also grow out of the presentation of a written communication to the assembly. This may be in the form of a letter or memorandum from a member who is not present, from a superior body, such as a state or national executive board, to a local chapter, or from an outside source. A communication normally is addressed to the president or secretary and is read aloud by the secretary, unless the presiding officer properly should read it because of special importance of the content or source. It is not customary It is not customary to make a motion to receive a communication or a committee report, which means only to permit or cause such a paper to be read. This is an example of a case in the ordinary routine of business where the formality of a motion is dispensed with. It should be noted that a motion to receive a communication after it has been read is meaningless and is therefore not in order. The reading of a communication does not in itself formally bring a question before the assembly. After the reading, or at the time provided by the order of business, a motion can be offered proposing appropriate action. If no member feels that anything needs to be done, the matter is dropped without a motion. Business that comes up without a motion because of previous action. Business may come up automatically at a certain time or a certain order in the order of business. If it has previously been postponed, Chapter 14, or otherwise made a general or special order, Chapter 41. In such cases, the business is announced at the proper time by the chair, and, if it has already been introduced in the form of a motion, no additional motion is made at that time. Obtaining and assigning the floor. Before a member in an assembly can make a motion or speak in debate, the parliamentary name given to any form of discussion of the merits of a motion, he must obtain the floor. That is, he must be recognized by the chair as having the exclusive right to be heard at that time. For the parliamentary motions that can be made without obtaining the floor, see pages T44 through T45. The chair must recognize any member who seeks the floor while entitled to it. To claim the floor, a member rises at his place when no one else has the floor, or goes to a microphone in a large hall, faces the chair, and says, "Mr. President," or "Madam Chairman," or "Mr. Chairman," or whatever is the chair's proper title. Note: in small boards and committees, members generally need not rise to obtain the floor. See 4921.1. Back to reading. If the member is entitled to the floor at the time, the chair recognizes him, normally by announcing, as applicable, the person's name or title, or the place or unit that he represents. This member then has the floor. Note, the expression privileges of the floor, sometimes used in legislative bodies or conventions, has nothing to do with having the floor, but means merely that a person is permitted to enter the portion of the whole floor otherwise restricted to members and necessary staff. It carries no right to speak or any other right of membership, except as may be determined by rules or actions of the body. Back to reading. And can remain standing and speak in debate or make a motion as permitted under the rules in this book, depending on the parliamentary situation at the time. If only one person is seeking the floor in a small meeting where all present know and can clearly see one another, the chair can recognize the member merely by nodding to him. On the other hand, if speech is prearranged or several members are attending to claim the floor at once in a large meeting, presiding officers often use the formal wording, "The chair recognizes Mr. Smith." When the names of the members are not generally known, a person addressing the chair to claim the floor states his name and any necessary information as soon as the presiding officer turns toward him, as Edward Wells, delegate, Crescent County. The chair then assigns the floor by repeating the member's name or identification. When the member finishes speaking, he yields the floor by resuming his seat. If two or more rise at about the same time, the general rule is that, all other things being equal, the member who rose and addressed the chair first after the floor was yielded is entitled to be recognized. A member cannot establish prior claim to the floor by rising before it has been yielded. In principle, it is out of order to rise or be standing while another person has the floor, except for the purpose of making one of the motions or taking up one of the parliamentary steps that can legitimately interrupt at such time. See pages T44 through T45. In a very large assembly, if members must walk some distance to microphones, it may be necessary to vary from the preceding rule as dictated by conditions in a particular hall. Some arrangements used in large assemblies are outlined in 42:16 through 17. While the motion is open to debate, there are three important cases where the floor is properly assigned to a person who may not have been the first to rise and address the chair, but who did so before anyone had actually been recognized. These cases are as follows. 1. If the member who made the motion claims the floor and has not already spoken on the question, he is entitled to be recognized in preference to other members. 2. No one is entitled to the floor a second time in debate on the same motion on the same day as long as any other member who hasn't spoken on this motion desires the floor. 3. In cases where the chair knows the person seeking the floor have opposite opinions on the question, and the member to be recognized is not determined by one or two above, the chair lets the floor alternate, as far as possible, between those favoring and those opposing the measure. To accomplish this, the chair may say, for example, since the last speaker spoke in favor of the motion, who wishes to speak in opposition to the motion? Or, since the last speaker opposed the motion, who wishes to speak in its favor? A member cannot rise for the purpose of claiming preference in being recognized, as this right is called in all of the above cases after the chair has recognized another member. If at any time the chair makes a mistake, however, and assigns the floor to the wrong person, when preference and recognition wasn't timely claimed or in any other case, his attention can be called to it by raising a point of order, Chapter 23, and he must immediately correct the error. The preceding rules usually are adequate for assigning the floor in most business meetings. In great assemblies or conventions, or in bodies that must handle heavy agenda or complex issues, additional situations often occur where the best interests of the assembly require the floor to be assigned to a claimant who was not the first to rise and address the chair. For the rules governing these cases, see Chapter 42.